Tom has been practicing law for some 30 years after graduating from Williams College and the University of Oklahoma. He has practiced in the realm of personal injury, auto accidents, medical malpractice, and work comp. And today we're here to interview him as he's dealt with a lot of legal issues of the chronic pain patient. I am here to do the interview and discuss some legal issues that involve people who have chronic pain. Tom has dealt with many patients that have chronic pain, including chronic regional pain syndrome, failed back syndrome. I'm interested, Tom, what is your story? How did you end up becoming a lawyer and find yourself in this area of law?
Well, I wanted to be a lawyer ever since I was a child, and it's always appealed to me. It's always been the courtroom that appealed to me, the battle in the courtroom. It always seemed to me like a battle between forces of good and evil. I know that sounds kind of melodramatic, but it sure seems like that to me even to this day. I enjoy it.
All right. Well, now I know you've dealt with a lot of chronic pain patients because of the nature of your practice. Things like chronic regional pain syndrome, medical malpractice injury, chronic failed back syndrome from multiple surgeries. And I know dealing with chronic pain patients, you've learned that they're a little different than your average client. They have special advocacy needs and assistance and probably require a little more help. What have you learned by dealing with chronic pain patients and pain patients in general?
Well, it's the people that I've represented have affected me. They, for the most part, have been very courageous people. They've certainly suffered more than I can imagine, not having been through what they've been through. They've got some terrible problems of transportation. It's difficult for them to concentrate. And trials, the short trial is 3 days. I mean, that's unbelievably short. That's about as short as you can pick a jury, make opening and closing statements, put on some evidence, and have the jury deliberate. And for a person with chronic pain to sit in that courtroom, sit at that counsel table for 3 days, at a minimum, that's almost more than you can ask of them. So there's some terrible challenges as far as having them appear for discovery, to give depositions. There are a lot of demands, and believe me, the defense lawyers know it, and they'll try to discourage someone with chronic pain and make them want to settle their cases cheap by trying to put them through their paces that are difficult for them to do.
I know that a lot of people, once they have a painful injury or any kind of injury, they're now out of work and they do have financial pressures. And obviously that's to the advantage of the other side. How quickly and can you usually get a case settled? I was just wondering. Let's say a personal injury case.
Well, of course, all cases are different. Some cases settle quickly, some cases do not. I have one right now where they've filed a spurious motion to dismiss, and then they filed another one after that. I mean, and they've managed to delay a case for almost a year without ever filing an answer. Now defense lawyers and insurance companies, because that's who really drives the boat on these things, they know that people are having economic difficulties. They know that they need to be able to settle their cases because they're just desperate for money. And so these cases do take a while because we get no cooperation. Federal court's better. They don't put up with a lot of nonsense from defense lawyers and insurance companies. But in state cases, and I'm not critical of state judges by any means, but state cases just take longer. Dockets are backed up. I file a motion. Sometimes it takes me 2 months before I can get a hearing on that motion. And that's not anybody's fault. That's just because it's backed up. But a person who undertakes litigation needs to be in it for the long haul.
Well, I know, speaking of financial pressures and and people with chronic pain. A lot of our people that follow my site have major pain disorders like arachnoiditis, chronic regional pain syndrome, failed back syndrome, etc. And they seek financial assistance through Social Security disability. What is the process of seeking disability, and when should you seek an attorney's help?
Well, if you are physically capable of filing a claim on your own, some cases are very clear. You know, let's say someone's in a terrible accident and is a paraplegic or quadriplegic. Very clearly that person cannot work, and there's really no need to hire an attorney and pay the attorney the 20% of the award that he would, or somewhere in that neighborhood where they would be awarded by the government for handling that case, because they're going to get put on Social Security disability very clearly if they're eligible for it. By that I mean if they paid in. But I'm not critical of somebody who does not want to do it, is somehow either physically unable to do it, like we talked about, or is just not up to it psychologically. We don't turn anybody away because they say they want us to do it for them. But generally, if they can file themselves, and if they're turned down the first time, then they come to us. At least we know that it's not something that would have been a slam dunk, that they didn't need a lawyer for. Now, I will say one other thing, getting back to the financial stress. A lot of people will borrow money from some of these loan companies that loan against their recovery. I think that's a terrible mistake. They end up with huge amounts of interest, and there's some horror stories about those. So we always recommend to our clients not to do that.
That's good advice. Many of our people that follow us have disorders that relate to medical injury. Chronic regional pain syndrome, maybe a carpal tunnel surgery went bad, a arachnoiditis epidural went bad, or a back surgery. They're very interested in knowing how do they know when they have a medical malpractice case. What are the features of something like that?
Well, as the doctors are fond of saying, medicine is an art and not a science, and any time that they undertake a procedure, it's sort of like a forward pass. In football, things can go wrong. An interception or incomplete pass. Sometimes things don't work out, and it's through no fault of the doctor. But a lot of times it is from the fault of the doctor. And it's hard for a layperson to know. So it's essential that you act very, very quickly. Get your medical records, because medical records are oftentimes altered. Now they'll say they want the record to speak the truth, so they alter them that way, but a lot of times they just alter them to be able to protect themselves from medical malpractice cases. Get the records immediately, take them to somebody for a review. Someone who does medical malpractice work. We do medical malpractice work. We have a network of doctors that we use, doctors in different specialties. If we don't have one, we can sure find one. And we have that doctor review the case to determine if a physician or a nurse or hospital has fallen below minimum accepted standards of care. And that's the definition of negligence in medical cases. For that matter, for legal cases too, for lawyers, or for engineers, or for people that build houses. Did they fall below the standard of care that's expected of someone in that profession? And that's a hard call for a layperson. So it's important to bring in some kind of an expert to do a review of the facts to make sure the case is there, because you don't want to sue somebody if the case isn't there. If they didn't commit negligence, you don't want to sue them because it's not right, first of all, and secondly, it's expensive, and it's an expensive mistake.
So if someone gets injured during a medical procedure, they should seek an attorney that can seek an expert and review their case and see if that was medical malpractice?
Absolutely, and they should do it quickly.
Okay. Another issue that we're seeing with our followers, and we've been getting a lot of feedback about is a lot of the injuries actually occur at work. We have a lot of people that have workman's comp injuries. Some of them then go get procedures that actually make them worse, but in many instances they have a work injury and they feel intimidated that they cannot proceed with that workman's comp claim. Now, I know workman's compensation is changing a lot, and I'd like for you to speak to the changes we're seeing in workman's comp and the intimidation that's sometimes involved.
Well, there's a terrible change, in my view, that's going to occur next November, and that's going to be that workers' comp is going to become administrative action instead of an action where you can hire your lawyer and be represented. In the administrative action, you're not going to be able to do that under the law as it is now. The administrative system that they've passed into law, that our legislature has seen fit to pass into law, doesn't save any money over the adversarial system that we have right now, where there's two sides of the story and a judge makes a decision. It doesn't save a bit of money. Where they're saving money, and they'll tell you they're saving money on it, is they've reduced the benefits for hurt people. The benefits for hurt people have gone down, and that's what the savings of this program is. That's what it consists of. But until November of 2014, you can still file a workers' comp action, and it's an action that arises out of and in the course of employment. It could be as simple as, falling on a floor at work, and it is negligence-free. There's no issue of whether it was your fault or somebody else's fault. There are certain areas that you can't recover from if somebody is hurt as a result of horseplay, for example. Then that's not covered. But for the most part, an accidental injury arising out of and in the course of employment is covered. Now, you're supposed to be paid quickly. That generally does not happen. They generally will, again, try to starve you out and take a bunch of time before they will pay you on it. But the idea was, when the legislature initially passed this many, many years ago, was that it was to keep people off of the dole, keep them off of welfare, that they have families they had to feed. It's not fair when a person's injured through no fault of their own. In the course of serving their employer, they're supposed to have their medical bills paid for. Now, what the employer gets for this, and the bargain that they seem to have forgotten about, is that the employer pays a reduced set amount for this injury. It's a certain number of weeks of the average weekly wage. And they determine what the average weekly wage is for workers in Oklahoma, and they set it and periodically raise it. And each injury is scheduled, percentage for this much, like say a loss of a limb is a percentage, loss of a life is a certain amount of money. In any event, it's supposed to be quick, and it is quicker than litigation in district court. And it's supposed to be sure. Most of those cases are settled as well, but some of them do go to trial.
So, this may not be a question for you, but is there any activism against this action to change it from from legal to administrative? Is there any political activity going on, or?
Well, there was, and it was unsuccessful.
Okay.
And this legislature, passed it. And the governor signed it, and everyone on that side of the fence is talking about what a wonderful thing it is for the worker, and I don't see that at all.
Are these kind of things happening throughout the United States?
Well, we got our form of this from Texas, which of course, a lot of people think that we need to be Texas light, I guess, here in Oklahoma. They want to adopt all the changes Texas has made, and I've got some first-hand information about the way the Texas system has worked, and it doesn't work at all.
Okay.
It just doesn't compensate people who have been terribly injured.
Can you speak to the intimidation factor that some of the workmen's comp, that they're scared of filing and then they're scared of going through with it?
Well, one area that we have been pretty active in is in suing employers for terminating an employee because they have filed a workers' compensation claim. Now, talk about intimidation. Most workers are intimidated into not filing a workers' compensation claim, because the scuttlebutt around the office place or workplace is, if you file a workers' compensation claim, you will get canned. And that has happened. It happens frequently. And sometimes it happens blatantly. That if a person is fired for no good reason after they filed a workers' compensation claim, I think it's something that we would look into in this law firm. I think other law firms would too.
Okay. Two more questions. When someone has a serious injury or auto accident and suffer pain, when should they seek the assistance of an attorney, or should they rely on the insurance company?
Well, the insurance company is not your friend. The insurance company is in business. It's a corporation. It's not a human being. I don't care what anybody says. They're not people. They are soulless entities. And that's not a criticism. It's just an accurate description. Their whole purpose is to make money. They don't make money by paying fair amounts for injuries. They make money by not paying people fair amounts for their injuries, or paying them nothing for their injuries. So putting your trust in an insurance company to pay you what your injury is worth is like putting the fox in charge of the hen house. It's just a bad idea. You don't have to pay a lawyer to go and talk to them, and you can even take to them what your medical bills are, what the facts of the accident are, and what the offer of the insurance company is, and go see several of them. Go see more than one lawyer. And sometimes people have come to see me and say, I just don't think I could do any better than that. I think that you probably ought to go ahead and settle with them directly, because it's cheaper than if you hire me, because I will have to get paid a percentage of whatever it is that's recovered. Because that's generally how we work. We don't charge the people anything that come in to see us. If we basically eat what we kill, if we're able to make money for them, then we get a percentage of the money that we're able to make for them.
Okay. Recently, there's been a lot of news about class action suits. In the community I work with, the chronic pain community, there's been a lot of questions about being involved in these class action suits against orthopedic devices, hip devices, electronic devices. Recently, there's been a lot of news about the compounding agents that were used and can have contaminants that were used in epidurals. But a lot of people don't even understand what a class action suit is. What is a class action suit?
A class action suit is basically a legal construct where a large group of people who are similarly situated are able to collectively sue one or several defendants. Now, they have to have in common, the cause of action has to be the same cause of action. Now, the damages are going to vary from person to person, but the things that you're describing, the kinds of class actions you're describing, are classic class action cases where someone is injured by negligently devised or designed product. Something that, like, thalidomide is an example. Thalidomide was anti-nausea medication that was given to pregnant mothers that ended up causing terrible, terrible deformities. And so everyone, I don't know if there actually was a thalidomide class action, but that would be a good example of a class action suit.
All right. Well, is there, do you have any other comments or any other issues you think should bring up for our listeners?
Well, just one thing. Some people are a little bit embarrassed about filing a lawsuit. I mean, what they see on TV and the advertisements that they read from the insurance company say, well, if you are injured, you should just bear that yourself. Don't make the person who caused this damage pay for it. I feel very strongly that this is what I do promotes a very conservative American value, and that is that if you break it, you pay for it. What the insurance companies want is basically some kind of a form of welfare for rich corporations. They want the poor person who's injured to pay the damage that's been done to them, pay it themselves, and not force the person that has caused it to pay for it. And that is not the American way, and that's not a conservative value. Conservative value is, if I do something wrong, I take care of it.
Well, thank you very much for today's interview. This is Dr. Kent from mychronicpain.com, and we thank you for your advocacy and your understanding for chronic pain patients.
My pleasure. Thank you.